Alex here with another video on high conflict child custody. This video is going to be on termination of parental rights. So first I'm going to cover some general overarching principles of what termination of parental rights is and entails, and then I'll mention how it works specifically in my case. So a termination of parental rights, in Nevada at least, is both the termination of your parental rights and your obligations. This is definitely not the case in every state. Some states you can have your rights terminated and not your obligations, so you can still be on the hook for child support and stuff. Because of the fact that they are linked in Nevada, there was a recent case, and again I won't mention specifics, you have to do your own research, but there was a recent case that went to the Supreme Court, and they mentioned that you can't just terminate your parental rights to get out of paying child support. The Supreme Court of Nevada discussed at length that basically would just cause, first off, it really wouldn't change the situation for a child. If a child has a parent who is obligated to pay for his or her support, terminating their parental rights when they're already not spending time with their child and when they're already not paying for them anyway really doesn't do anything for the child at all. It basically makes it so that the child has a non-involved, non-paying parent who's on the hook, and afterwards it's a non-involved, non-paying parent who's no longer on the hook, and basically the government's on the hook. So this does tie into my last video where I mentioned adoption. Adoption allows anyone to basically take on the parental rights and obligations of a child. And that was one of the ways that I was able to terminate my ex's parental rights, basically to clear the path for adoption. This is typically how the government does it too. When the government, like Department of, Family Services or Child Protective Services, when they terminate a person's parental rights, they have to basically come up with a permanency plan, and most of the time it is to adopt the child to somebody else. There are some rare situations where guardianship is fine, like if it's with like the grandparents or something. Even then they're going to try to push adoption, but some grandparents just, they might feel like that's overstepping a line or something, and so the government might work with them. But most of the time, Child Protective Services is going to try to adopt a child who's had their parents' parental rights terminated. So in my case, first let me cover some of the grounds. There's quite a few grounds to terminate parental rights. Most of them are really hard. So like you can try to establish that there's a severe child abuse and neglect, but it has to go to such a severe level that curtailing the parents' parental rights isn't enough. So a lot of times there will be problem parents or drug addict parents or alcoholic parents, but the court would rather just curtail their parental rights to the point of making them a non-custodial parent, giving them supervised visitation, maybe even telephonic visitation, stuff like that. The termination of parental rights when it comes to abuse and neglect is so bad that the government is basically erasing the parent from that child's life. In fact, the Supreme Court of the United States says it's tantamount to a civil death sentence. Basically, they're saying that you're legally dead to the child as far as the government's concerned. So to try to terminate someone's parental rights on child abuse or neglect is really, really hard, aside from having to show that there's basically no hope for this child, that the abuse is so bad that you have to totally remove the parent forever. You also have a higher burden of proof. So like in a child custody dispute, it's preponderance of the evidence. Well, if you're trying to terminate their parental rights, it is clear and convincing evidence standard. And that actually is in a SCOTUS decision, Supreme Court of the United States decision, that the termination of parental rights in all 50 states has to be at that standard of proof. I found that to be rather surprising. The other issue is that, at least in Nevada, they're entitled to an attorney. So in a child custody dispute, they're not. But if you try to terminate their parental rights on abuse and neglect, they're entitled to a free attorney in Nevada. So that's just another hurdle. There is a much easier way to do it, and that's the way I did it, and that's abandonment. Once I curtailed my ex's parental rights so severely in the original child custody matter, she basically checked out. She pretty much left, and nobody knew where she went, and she didn't call, didn't send any messages, didn't pay her child support, and after 6 months I can terminate her parental rights under abandonment, and that's basically the easiest way to do it, because all you have to do is show that they haven't contacted, visited, sent any gifts for 6 months, and then the court is presumed, or abandonment is presumed, and the court can terminate her parental rights. Now, of course, I mentioned you have to have sort of a substitute in place. If I didn't, if my wife wasn't willing to adopt my son, I wouldn't be able to terminate my ex's parental rights because, as I mentioned in the beginning of this video, it really doesn't change the situation for the child. It's just like, I'm going to go ahead and repeat it. You're basically taking a non-involved, non-paying parent who's on the hook and making it so that you have a non-involved, non-paying parent who is off the hook. So that doesn't help anything. It doesn't help the government, doesn't help the child. But if you can go to the court and say, hey, I filed a petition for adoption, and my wife, his stepmom, is going to adopt him, that's a different situation because the situation goes from a non-paying, non-involved parent to a paying, involved parent. So that's the situation. That was the situation in my case. I'm going to also add that in Nevada, if you do terminate a parent's parental rights and the child isn't adopted, that parent can come back later and try to have their parental rights, I think it's called, restored. But once the child is adopted, the termination of parental rights is irrevocable. Just as a side note, if you haven't seen my adoption video, which was yesterday, I believe I published that one, check it out. But basically, one of the issues with an adoption is you need the consent. In the statutes, it mentions you need the consent of any natural parents or legal custodians, and the termination of parental rights is a way to get around that. And I did mention that in that video, so I'll just mention it again. By terminating my ex's parental rights, I no longer needed her consent to the adoption. The last thing I'm going to mention is a few more specific. I did promise specifics. I don't like to give specifics because you never know when the law will change, and it might lead somebody who wants to follow my my video or my story. It might lead you down the wrong path because statutes change. But I will go ahead, now that I've given you the disclaimer that statutes change, and please check this for yourself. There actually are no self-help forms in Nevada on termination of parental rights or adoption. So I did have to do the paperwork myself, and basically this is what I did. I filed something called a petition for termination of parental rights and a petition for adoption. Two separate petitions, two different court cases. The petition for adoption had as petitioners me and my wife. There was no adverse party. And then my son was listed as the minor. The petition for termination of parental rights had me as petitioner and my ex as a respondent, with my son as a minor party. Once I instituted these two cases, the first thing I noticed is that the adoption didn't have a hearing set. So I found out that to set a hearing, you have to file something called a notice of readiness and for setting. But I held off on that because the case wasn't ready. First, I had to terminate her parental rights. So I did take care of one minor issue in the adoption case. I noticed that the statutes required me to set forth a list of expenses that were being paid for. And there was a second thing. I had to consent to something called a welfare investigation. I think it's like some kind of home inspection or something like that. I got around those because I found out I could just file a motion to get a waiver from the court if I could show that I was within the 3rd degree of consanguinity, which is blood, which I am because I'm his natural father. So I went ahead and filed motions to do that. I can't give you the case numbers because termination of parental rights and adoption are confidential, but I'm at least going to walk you through what I filed. When I filed those two motions, they were immediately granted by the court. So she waived, the judge was Jennifer Elliott, she waived my welfare investigation and she waived my affidavit for expenses. That basically cleared the path for adoption with the exception of getting the consent. In the termination of parental rights case, I mentioned I couldn't find my ex, so I couldn't serve her under the ordinary, basically you track her down and serve her the papers. Instead, I had to do a motion for service by publication. I'm actually going to do a separate video on what this is. It basically allows you to serve somebody who you can't find through the newspaper. So I filed that motion. After a couple of weeks, the judge granted it, and they put the summons in the newspaper. So rather than give her the summons, it's put in the newspaper. Once that was done, I went ahead and set the hearing on the adoption to the exact same date as the hearing on the termination of parental rights. Oh, I forgot to mention, when you file a termination of parental rights, the hearing is set immediately at the date of filing. So I just had the adoption set on that same date because I wanted to get both done at the same time. In retrospect, I don't recommend doing this because in my case, nothing bad happened, but some people like to take pictures and stuff, and I was one of those people. And it's better to get the termination of parental rights done first, so that way you know that at the adoption hearing your ex won't show up, and you'll be able to actually have a happy day and get all those pictures with your family without stressing. So I set them on the same day because I wanted to get it all done at once. And there was a little bit of anxiety because I had no idea if she was actually going to show up on that day. And luckily she didn't. She didn't show up, so we still managed to take pictures and stuff. But in hindsight, I wouldn't have done that, and just recommend anyone here if you're going to go ahead and do that. In fact, I heard it was irregular. I did hire an attorney after all the paperwork was filed just to talk at the hearing. It was like $1,700. It would have been much more if he had to do the paperwork too. But anyway, yeah, he mentioned that he'd never seen that before. He didn't think the judge was going to allow it, but she did. She said both hearings on the same day. My son showed up. It was about 5 minutes to terminate a parental rights and about 5 more minutes to adopt her. It was so quick. I had never been through a quick process like that before, but it was, in fact, it was the quickest couple of hearings that I ever had in all 9 years of self-litigating. So with that, I will see you guys next time. Looking forward to going on with the High Conflict Child Custody channel.